Hi, this is a presentation from Legal Aid of Southeast and Central Ohio. Today our question is, my child is being disciplined at school. What can I do? Each year, public schools must give students a copy of a book called the Student Code of Conduct, with rules for behavior and the kinds of things that can lead to discipline. If a school plans to punish a student for breaking these rules, it must give them the chance to challenge the decision. This is called an appeal. Schools discipline students in different ways, and each kind has different appeal rights and deadlines. Some discipline happens in school, like the loss of field trips, recess, or extracurricular activities. It could also be a timeout, a detention, or what is called an in-school suspension, where students are often placed in a different room to do classwork. Other kinds of discipline involve removing the student from school property for a period of time, usually without access to their schoolwork. These are called removals, and schools are not allowed to use them for students younger than 4th grade, except to protect the safety of others. If a school sends a student home for 10 school days or less, it is called an out-of-school suspension. Removals over 10 days are called expulsions. If a student is expelled, they can try to change schools, but the new school may honor the decision and deny enrollment for that time period. Schools can also send students home for the rest of the day. This is called an emergency removal and should only be used if a student's behavior puts themselves or others in danger. If a student is sent home for any other reason, families should make sure the discipline is recorded as an out-of-school suspension in the student's records. Families should always ask for paperwork showing school removals. Students can be expelled for as long as 1 year if they bring a knife or gun to school, make a bomb threat, or hurt someone or something. Schools cannot use some kinds of discipline at all, like spanking. Other kinds, like restraint or seclusion, can only be used by trained staff if they are the only way to keep people safe. Appeal meetings give a student the chance to tell their side of the story to a neutral person in charge. Students can bring an advocate, like an attorney, to help them. To be able to challenge the school's decision, families should make sure to attend any scheduled meetings and not to miss appeal deadlines. For more on how to prepare for an appeal meeting, see our website at lasco.org/education. Before deciding to remove a student, someone in charge, like a school principal, will meet with them and ask their side of the story before making a decision. For suspensions, this meeting happens the same day, and family does not have the right to be there. A proposed expulsion can follow an emergency removal or suspension, even if the student was already removed for the same thing. Unlike suspensions, family members have the right to be at this meeting. Schools must send the details in writing ahead of time and must have the meeting within 3 to 5 days, or 1 day, if the expulsion follows an emergency removal. It is important to attend these meetings and to appeal school removals because they give folks time to think after things have calmed down and everyone can be more neutral about it. It also allows families to bring up things that the school should know about, like if the student has a health problem, has experienced a loss, or has been bullied at school. If the appeal is successful, a school may do things like give a student access to their classwork while they are out of school, let them come back to school sooner, or erase the discipline from their record. Sometimes, the school will look at whether special education helps them learn to manage their behavior. For more on this topic, see our website at lasco.org/education. After these meetings, if the school chooses to remove the student, it must send a letter within 1 school day that explains the decision and how to appeal, where families can have a new meeting scheduled with a different person in charge. If the school still does not change its mind, families can appeal to the County Court of Common Pleas. Reach out to legal aid if any of the following things apply to you. You do not think the school followed the rules to remove your student. You wish to appeal a removal. You have a student with an IEP or 504 plan who has been sent home early for more than 10 school days in one school year. You have a student facing removal, and you think the behavior was related to a health problem. Here at Legal Aid of Southeast and Central Ohio, we help people who are low income, seniors, and veterans in 36 Ohio counties. You can reach us at 1-888-246-4420 or at lasco.org. Thanks for watching and take care.